Guys, Linda Muscarello here, also known as the Queen of Foreclosure, and I want to share some information with you that I know you need. How do I know you need this? Because too many of you have been coming to me requesting consultation because of problems you're finding after purchasing property at the Homeowners Association foreclosure. So, at the auction, I want to make sure you know what you're doing and that you won't wind up being a story in my next class about I met this lady and man, let me tell you what happened. So that doesn't have to be you. We're talking about when you purchase these properties at the auction, you're often planning to resell the property at some point. To do that, you're going to want to get title insurance. Title insurance does what any insurance does. It protects the insured against a risk of loss. What type of risk of loss are we talking about with title insurance? Well, we're talking about making sure that when the person purchases the property, they are getting 100% of the ownership interest and that there are no unaccounted for debts that may occur in the future that were related to the property, such as, oh, I just put a new roof on and that wasn't paid for, and there's a lien on that, and that is attached to the property. So title insurance means that the title company examines everything related to the title and then determine that everything is good and they give an insurance policy, and it's definitely well worth getting. Anytime you can purchase property with title insurance, you absolutely should. And when you get ready to sell the property, your borrower, as I say, will want to borrow your buyer. See, they're the same thing in my mind because your buyer is likely a borrower. They're not likely to be purchasing the property cash, and they will need title insurance in order to be able to get the loan to buy the property from you. So it's definitely important that you get property that either has title insurance when you purchase it, which you cannot do at the auction. They do not give title insurance on that purchase, but the title could be insurable but not insured. Well, how can you know if it's going to be insurable and when it will be insurable? Well, that's what I'm here for now. So let's just jump right into it. First, let me let you know my disclaimer, which is I'm not an attorney and I'm not dispensing legal advice to you. If legal advice and or other expert assistance is required, the service of a competent professional should be sought. Also, you should know that I am going to be reading to you directly from correspondence I've received from a title company recently on this specific issue. So I'm in the notes here on these slides, what you're seeing is directly from them. So even if they had misspellings, I left them in. So you know, if you see something misspelled, it did not come from the Queen, okay? But for the sake of accuracy, I'm just giving it to you just like I got it, all right? So if it's a bullet point here, is this what they told me? The first thing I want you to know is that they're saying right here that there's really a 3-page listing of requirements. So they can't encapsulate all this in like these 6 points that I'm going to be covering for you, but this will be hitting the high points, things that you need to know. First, look to the restrictions to determine if the HOA or assessments are subordinated to the purchase money mortgage to determine priority. So I'll have to kind of explain a few things to you. What are these restrictions? What do I mean by that? And what do I mean by subordinate? Okay, very good questions. Glad you asked. Uh, these restrictions are going to be found in the records for the county when a subdivision is formed and they create deed restrictions. They make that a matter of public record. These documents can also detail the power that the homeowners association has with regards to their power of sale and liens, and whether or not their lien would be superior to the mortgage lien. What we mean by superior is what we're getting to this next thing about subordinated. And what that means is that liens get what are called positions of priority. And this is according to chronology. So when a property is purchased, the money borrowed to buy the property, which is what you think of as a mortgage, creates what is called a purchase money lien. This is a first lien because chronologically it's on the property before any other liens could be on the property. Let's say if the next year you decided to borrow additional money for home improvement. For example, you decide you want to install a pool. So then you get a mechanics lien. This mechanics lien would be inferior to the purchase money lien. When a lien is inferior in these types of foreclosures, we're talking non-judicial foreclosures, bank foreclosures, first of all, like non-judicial bank foreclosure. What would happen is the foreclosure of a lien can extinguish, meaning totally wipe out, existing liens that are inferior to the foreclosing lien. I want you to remember that, but to remember that that is specific to the non-judicial foreclosure liens, such as a mortgage foreclosure. This will not apply the same to the homeowners association foreclosure. Typically, you're going to find that in Texas, the homeowners association assessment lien will be inferior to the mortgage lien. I see people going to the auctions all the time, spending in excess of $100,000 to purchase property through a homeowners association foreclosure, only to find that there's already another mortgage lien on the property. So maybe you paid $100,000 at the auction for a property that's worth $200,000, only to find that there's already a $150,000 mortgage on that property. These are things that you can determine before you purchase at the auction, and that's what I'm here to help you with today. So that's what we mean by the restrictions, and now you know what I mean by liens being subordinated. And so you need to be able to determine that. The next thing that the title company told me, they said, because of repeated claims on this issue, we will not ensure that liens were cut off by a homeowners association foreclosure unless more than 5 years have passed since the foreclosure sale, even with a declaratory judgment stating that the liens are cut off. So that's interesting. They're saying that even if this property for HOA foreclosure would be one where there are liens that would be inferior, which would be eligible to be extinguished by the HOA foreclosure, they're saying we will still not insure for 5 years, even in that case, even if it's a declaratory judgment in the lawsuit, even if the judge says that, they're still saying we will not give title insurance. Because remember what title insurance does is there's it is aware, we are all aware that you cannot zero out risk. What you can do is assess risk, which is what title companies do as well, take steps to minimize the risk, and then determine what is an acceptable risk level for you. So one title company may be willing to take risks that another one will not be willing to, and that is their priority. I mean, what do you call that? Not their priority, but that's your, it'll come to me later. But you know what I'm saying. They have the right to do that because it's their business. So let's see, it's gonna stick in my mind. I'll have to come back to that word. Anyway, prerogative. That's it. Like Bobby Brown, my prerogative. Don't get me started. I get musical and then getting back to this. Okay, so it is their prerogative to determine that even though the judge has stated that this lien is one that would be eligible to be extinguished, they're choosing, and it is their prerogative to do so, they're choosing not to insure that unless 5 years pass. Okay, let's move on to the next slide. 2A, they will insure with exceptions to the liens. In other words, they're not insured. They will give insurance, but they're simply saying we'll insure everything else. We will give a title policy, but the policy, in other words, they can say we guarantee that this is the owner, and we can guarantee that these other facts that are known are there, but we will not guarantee that these debts that were inferior to the homeowners association lien, that those debts no longer exist. We will not insure that. They will do it, but they will do the title insurance, but not they're not ensuring that those liens have been cut off. That's for 5 years. So we will only insure with exception to those liens. Lenders have repeatedly come back as much as 4 years later, filed a bill of review. That's something that they have the right to do, that the lender does, asserted that they were not properly noticed and they have successfully set aside the foreclosure sale, which means it reversed everything. It's like that shouldn't have been a foreclosure from the beginning. So you may be wondering, what do you mean saying that they weren't properly noticed? I'll be getting to that. But first, you should know that the title company tells me it appears that the primary reason the lenders are not properly, which I believe they meant properly, noticed. But anyway, it appears that the primary reason that the lenders are not properly noticed is that they did not timely file their assignments of lien of record, but the courts have still ruled in the lender's favor. Here's what is meant by that. When a lender loans money, they have they have the debt instruments proving that they're the ones that are the holders of that debt. Now, lenders often sell their notes to other lenders. So you may buy a property and borrow your money from ABC Mortgage Company, and then eventually you get a letter saying, "Oh, we're XYZ Mortgage Company, we're your new lender. You just start sending your payments to us." So they sold your note. And they do it through the process called assignment. So there's a document called assignment. So whereas initially your debt was owed to ABC Mortgage Company, then ABC assigned it to XYZ. Well, XYZ then should file that in the records that, oh, yes, I'm the new holder of the note. But sometimes they don't do that in a timely fashion. Therefore, when the property it gets for foreclosure, from, for example, for an HOA, and the HOA sends a notice to any inferior lien holders, to warn them, hey, this property that you have a lien against is going to be a subject of a foreclosure action, and you're in a position where you can actually lose your rights related to this property because your lien can be extinguished. But they send the letter to the last lender of record, to the last one that's in the record, and that may have been ABC, because when ABC gave the assignment to XYZ didn't file it in a timely manner. So they'll just send the letter to who is the lender of record, meaning that the current lender may not receive the notice. And that's what's been creating some of the problems, because it's the title company is telling me here, it appears, oh, by the way, can you tell that purple's my favorite color? I think you can, huh? It appears that the primary reason that the lenders are not properly noticed is that they did not timely file their assignments of lien of record, which means it would be their fault. But the courts have still ruled in the lender's favor. So now let's move on to another point. Point number 3. Homeowners Association foreclosure can only be done judicially. No non-judicial foreclosures. This means that the Homeowners Association has to file a lawsuit and get service on all interested parties. When they say you've been served, that means there's a physical notice that says you have been served, citation here. Greetings, you have been served a citation for the lawsuit, you're being sued. So they're saying that if that didn't happen, you're not getting title insurance, because we will only give title insurance if the Homeowners Association did the lawsuit, did a judicial foreclosure and got service. Now let's talk a little bit more about that, because they have another point about that. Were all the owners served? What if you have a husband and wife and they only served one? Well, then the title company is not okay with this. All of the record title owners of the property must have been served in the underlying foreclosure lawsuit. The order of foreclosure must reflect the names of all of the record title owners of the property, meaning that should have been an order that was issued, like from the judge, saying, okay, you're ordered to sell this property. But every person who had the ownership interest had to be named in that order, so they had an opportunity to protect their position. What was the manner of service? That's my notes here. What was the manner of service? And did the people appear in court? Those are the questions I'm asking. So what did it say here? The title company says, if service is by citation or other substitute service, and the defendants did not formally appear in court, we will not insure title until 5 years following the rendering of the judgment of foreclosure. So I have to tell you what citation, service by citation mean, and substitute service. But basically what this means is they can have a constable, and have someone from the constable's office actually go and give the notice to the person in their hand. You've been served. or they can have someone, a representative, come there and file, give the notice to a person there in their hand, or they can post it on the door. But there's sometimes when the people have moved out, they can't, there's no one to answer the door. They'll make repeated attempts, and they will document their repeated attempts. Then they will, if the people have moved out or new people have moved in, maybe there's no way to put it on the door. Sometimes who knows what has happened. But the point is, they do need to get this into the person's hand in any way that they possibly can. So if they can't find the person, because another thing is, unfortunately, sometimes the people may have passed away, and they can't serve that person. They would need to serve that person's estate. At this point, they don't even know who that person is in terms of the representative of that person's estate, because had there been a probate file, it is so convoluted. So what they do is they go to, for example, if Sally Johnson is the one in foreclosure, their objective is to walk to the door, ring the bell, and she opens the door, and you hand her the citation. But if that's not possible, and it's not possible to serve this place, they will try to determine other locations that she may be and try to serve her at those other locations. But if all else fails, they can do what is called service by citation, which means they will post it in our area's legal newspaper that they made every effort. They will ask the court, will you allow us to serve this person through public citation? And they will show how they attempted. They will say, we went here on this day, this day, and this day, and we talked to neighbors, and well, no one could find this person, and so forth and so on. And then we did our research, and we did a background search, and this is all that we could find out. It seems impossible for us to reach this person, but we have to serve notice. So, Judge, will you give us the ability to serve through citation? And this, so by the way, our area's legal newspaper here for Harris County is the Daily Court Review. If you're in a different county, then you would just find out what is your area's legal newspaper. So the judge can say yes, and then the Daily Court Review of the area's legal newspaper will put the notice in there. Everything related to this matter, basically that this lawsuit has been filed, and here's the plaintiff, for example, ABC, Homeowners Association, and here's the defendant, which named that individual, and the information regarding the property and the information regarding the debt that is allegedly owed or at that time to the Homeowners Association. Okay, and there's different other types of, like, basically the point we're making here is that's not making the title company happy, because there's a potential that that individual just did not even get information and know that there was a lawsuit. And it says right here, the person did not formally appear in court. So in this case, if two things happen, they both happen. They served it by citation or other substitute service, and that defendant did not formally appear in court. So they said in that case, we will not ensure the title until 5 years following the rendering of the judgment of foreclosure. That's that. So, did inferior lien holders get a chance to cure? Evidence that prior to the foreclosure lawsuit being filed, the Homeowners Association provided certified mail notice to all lien holders inferior to the Homeowners Association, providing the total amount of delinquency and giving any such lien holder 61 days to cure such delinquency. So if there is a lien holder that would be owed money, then and that lien is inferior to the Homeowners Association lien, then the Homeowners Association would have sent a certified mail notice to all the lien holders and then give them 61 days to cure the delinquency. Did that happen? Because if it didn't, then no. We don't think that we're going to give you title insurance. Number 6, and we're rounding this up now. Are we still in the redemption period? So what is the redemption period? The redemption period is a period of time during which the former owner can regain the ownership interest in the property. And that is done by giving the person who purchased the property at the auction the monies that they paid. And for there are different types of lawsuits that have redemption. So you may be thinking of somewhere the borrower, where the person who purchased the property at the auction is given some additional money in addition besides what they owed. But for the homeowners association, that is not the case. They're going to be given the money back that they paid, plus they could be compensated for monies that they've paid for additional property taxes that they paid on behalf of the for that property, and additional homeowners association assessment dues, I believe. Yeah, I think that those are. Yeah, that's it. Yeah, that's it. That's what they will get compensated for, and that they're not getting any extra money. It's not like plus a percentage on top of that. So, but when they do that, then when they request to redeem and they redeem the property, the redemption period really is 180 days, but they have the right to request a 10-day extension. So this is why it's considered to be a 190-day period. So under no circumstances will we ensure the statutory within the statutory redemption period, which is a minimum of 190 days from the date the notice required in number 5 is sent. So this is what the title company said. Bottom line, this is their words. Bottom line, under the most perfect of conditions, it will be a minimum of more than 6 months before we consider insuring. Most likely much longer than that. And when insuring, we will take exception to any liens on title, regardless of whether it appears to that they might be subordinate to HOA assessment for a period of at least 5 years. Now, they said, buy and sell quickly. I cannot conceive of a fact scenario where we would be comfortable insuring that. Of course, depending on your definition of quickly. Okay, so I want you to know how to keep up with this information and find out about this stuff yourself. If you want to know what the law says, you don't always just have to depend on others to tell you. I want you to know how to find out things before. And now also I'm going to give you a hack because it's something I haven't told you yet, which is fantastic, which like just blows all this out of the water. You need to hang on for this. This is good. Because so far this hasn't sounded like awesome, fun stuff, and I know it. But okay, so I want you to know that you can look for Vernon's Texas statutes and codes annotated, and they're updated, I believe, each year. And you can look this up online, and that gives you information along the Texas property codes and statutes where you can get accurate information. But this is what the title examiners will be looking at when they're looking at whether or not they should insure your property. They look at this type of information, so you can learn to look at it too. I figured it out. You can do it as well. But here's another thing. What's better than all that? Get ready. I feel like there should be a drum roll right here, because here's a question. Well, could you buy the property before the auction? Yes, you can. You can buy the property before the auction. This way you can avoid a lot of the pitfalls that I said are associated with the purchasing the property. So it's not a problem. The problem is not that you're buying homeowners association foreclosure or that you're buying property tax foreclosure. It's that you're buying the property probably without the knowledge that you should about the ownership interest in the title, also about how to get title insurance and when you'll be able to get title insurance, and that you're buying these issues that you have related to redemption are related to the purchase happening at the auction. You can buy the property before the auction. Tax foreclosures, homeowners association foreclosures, you can reach out to the owners and buy the properties before you don't have redemptive rights. You can even borrow money because you can get title insurance. So would you like to know more about that? I know you would love to know more, and I would love to teach you more. So when would be a good time for me to do that? I will be teaching a class on title research soon, and you can look at my website, queenofforeclosure.com, and there you can learn the information you need to learn about how to buy these properties, how to get the research done. Queenofforeclosure.com will give you that information. Now, if you're looking at this in February of 2022, I will be doing one February 26th. Yeah, so February 26th, I'll be doing that class. I have a lot of other classes and also have a lot of good free stuff that I like to share with you and a lot of free events. So go to my website, queenofforeclosure.com. I think you can remember that. And I'll look forward to seeing you there. Happy investing and stay blessed. Bye bye.